just cause, but must provide reasonable notice or pay in lieu of notice. Purpose of reasonable notice: allow employees to obtain alternate employment. Reward him or her for past service to employer. The employer's responsibility: check with an employment lawyer as to a reasonable notice period. The burden rests with the employer to be fair in its initial offer. A low offer by the employer will force the courts to determine what is reasonable, which may result in a higher settlement. Employee's responsibility: a very important duty the wrongfully dismissed employee has is the duty to mitigate his or her damages. A wrongfully dismissed employee cannot recover compensation from the employer for losses that he or she could reasonably have avoided. The employee will be entitled to no damages if he or she has successfully avoided all loss by obtaining another job, for example. If the employee has not done anything to mitigate his or her losses, the court will deduct from that employee's award for damages an amount of money equal to what a reasonable employee would have done to mitigate in the circumstances. This duty to mitigate, a general principle of contract law, has a radical effect in lessening the amount of money that an employee who has been wrongfully dismissed will get from his or her employer. Courts determine the length of notice by considering A, age, B, length of service, C, position. Higher positions obviously get more notice. D, availability of similar employment in today's market. E, quality of the employee's prior work record. And F, whether the employee was induced away from secure work. You entice them away from a secure job. The objective is to calculate how long it should take before an employee will find comparable alternative employment. Grounds for just cause: A, serious misconduct, health and safety issues, for example, physical abuse of another employee. B, habitual neglect of duty. C, serious incompetence. D, breach of trust, for example, theft, destroying property, etc. E, willful disobedience, for example, refusing to obey rules or directives. And F, excessive absenteeism. You should be aware that these are not automatic grounds for dismissal. You have to give employees a chance. You will have to show culminating incidents. Courts want to see a culminating series of events that resulted in the termination. These events must be part of documentation which supports termination as the only resolution for every offense. Progressive discipline. Courts also look for a progressive punishment process. Minor punishment at the first incident, an increase in severity for the next incident, and on up to termination. Warning of consequences. The organization must also provide evidence that the employee was advised in writing of the consequences of each action. Letters of warning, etc. For example, if an employee is dismissed for absenteeism and theft, culminating incidents, progressive severity, and warnings of consequences must be documented for each. Culminating incidents, progressive discipline, and warning of consequences should be a part of the organization's policy manual. In a unionized environment, these provisions are usually described in the collective agreement. But many organizations have simply paid hush money by paying dismissed employees anywhere from a week to a month per year of service, basically what a judge would have awarded, and terminated them without any documentation. To put this all together, here's what you'll have to prove in your documentation to substantiate termination for just cause and poor performance. 1. You must prove that there were measurable performance standards in place. 2. That the employee was aware and agreed to those standards. 3. That suitable training, supervision, etc. was given to meet those standards. 4. That the employee was unable to meet the standards of that job. And 5. That the employee was warned in writing of the consequences that he or she would be terminated if the standards were not met. Now we'll look at probationary employees. A probationary employee can successfully sue their employer for wrongful dismissal. Traditionally, a probationary period was used for the opportunity to assess a new hire's performance within a limited time and terminate his or her services without fear of litigation. Recent decisions taken by the courts, however, have indicated a shift towards protecting the probationary employee because they found some employers negligent in their duty to provide the required support. Here is a part of a decision by Noble J. of the Saskatchewan Court of Queen's Bench, whose remarks parallel the consensus that appears to be emerging among labor arbiters. The only onus that rests on an employer to justify the dismissal is that he show the court that he acted fairly and with reasonable diligence in determining whether or not the proposed employee is suitable in the job for which he was being tested. So long as the probationary employee is given a reasonable opportunity to demonstrate his ability to meet the standards the employer sets out when he is hired, including not only a testing of his skills, but also his ability to work in harmony with others, his potential usefulness to the employer in the future, and such other factors as the employer deems essential to the viable performance of the position, then he has no complaint. As for the employer, he cannot be held liable if his assessment of the probationary employee is based on such criteria and a fair and reasonable determination of the question. Most courts and arbiters today entitle the probationer to reasonable notice, or wages in lieu thereof, unless the employer can prove cause for summary dismissal. When recruiters hire employees on probation and the new hire has not performed satisfactorily, they should consider the following points before the decision to terminate. Opportunity. The employer must be able to prove that the employee was given a reasonable opportunity to demonstrate his or her abilities in terms of skill, compatibility with others, career potential, and other factors deemed necessary by the employer. Performance must be documented. Support. Terminated probationary employees have claimed that once hired, they were left on their own without proper direction. To ensure this practice does not continue, the employer will now have to provide documentation that the employee was given all the training and support promised. This means that the recruiter will now have the responsibility of ensuring that the hiring manager spends the time necessary to develop and orient the new hire during the probation period. In addition, documented interim appraisals will have to be conducted by the supervisor before probation ends. Increasing standards. If the supervisor arbitrarily increases the standards of performance when the abilities of the new hire are apparent, then the employee can claim wrongful dismissal. This is because employers have used this method to terminate a new hire for whom they had a personal dislike. Exaggerated claims. Applicants will provide data about their abilities during the selection interview. If the new hire cannot perform the work that he or she claimed they could, then the employee can be fired for cause. Look at the claims against the employers for wrongful dismissal. Once an employee has been deemed by the courts to have been wrongfully or constructively dismissed, employers can be forced to 1. Pay all money for regular hours the employee did not receive during the notice period. 2. Pay all benefits, dues, pensions, and bonuses due to the employee. 3. Pay damages for loss of reputation. 4. Pay damages for mental distress. 5. Could offer the employee the next available job in the company. And 6. Anything else that can reduce the impact of being wrongfully dismissed. Please take some time now to work through case study number 1 found in your handouts for this module. Here was the judge's decision. The Ontario court gave the employee 6 months' notice based on the corporation's failure to retrain the manager as they had promised to do. But the manager appealed to the Ontario Court of Appeal. Would the Court of Appeal uphold or overrule the trial judge's decision? What should be taken into consideration in assessing the notice period of the assistant manager? The appeal court decision. It would be unfair of the large corporation to treat the employee as a short-service employee upon dismissal, since it had not done so during his employment. Damages reflect a 12-month notice period over and above the 6 months already awarded. It's now time to learn what constructive dismissal is all about. One does not have to be terminated to be dismissed. If you receive a sudden unilateral transfer or a sudden unilateral salary cut, you can consider it as a dismissal and can sue for damages. Your employment contract guarantees the position, the salary, the location, and a host of other terms and conditions. If either side reneges on any provisions of the contract, then the other side can sue for damages. Definition of constructive dismissal. Any imposition by the employer to change the terms and conditions of employment without the employee's approval or consent in order to force or encourage the employee to consider leaving their job, such as transfer the employee without his or her consent, change the nature of the current job, demote, decrease wages, decrease in authority or responsibility, and forced resignation. The courts have granted that employers are allowed a certain degree of latitude with respect to changing an employee's job function under the following circumstances. The company is acting in good faith. 2. The company is furthering business interests. And 3. Change is necessary because of economic difficulties. Remember that an employee has a duty to mitigate his or her damages. What this means in the case of constructive dismissal is that the employee may be obliged to accept a demotion if the following circumstances are met, in order to mitigate his or her damages while looking for satisfactory alternative employment. Where the employee was promoted within the ranks of the company to the position from which he or she was dismissed, where the salary and benefits of the new position are comparable to those of the former position, where the working conditions, hours, and schedule of the new position are not substantially different from that of the old position, where the tasks of the new position are not objectively demeaning, and finally, where the personal relations between employee and employer did not deteriorate into acrimony prior to demotion. The failure of the employee in any of these circumstances to accept the new position would limit the amount of damages that the employee can recover for wrongful dismissal. Remembering this, in the economic times of downsizing and workplace reorganization, is key to employers who need to save money, and instead of providing hefty pay in lieu of notice, they may be able to demote employees so long as the lower positions satisfy the 5 characteristics listed above. Please take some time now to work through case study number 2, found in your handouts for this module. Here was the judge's decision. A man who was offered a lateral transfer with no cut in pay as an alternative to being let go was not constructively dismissed. Royal Trust was dealing fairly and in good faith with longtime employee Terry Cox in making the offer, noting that the move wouldn't have been a demotion and that the new job had been created especially for Cox. Relevant points in the case: 1. Royal Trust had documentation of Cox's poor performance as a manager with the agreement of Cox. Royal Trust could have dismissed him with just cause. 2. In lieu of a decision to terminate Cox, they asked him to accept a transfer to another position of equal status in the company. And 3. Cox's decision not to accept the transfer, therefore, amounted to a resignation, and Cox had no right to sue for wrongful or constructive dismissal. Now consider letters of offer. Why let a court decide what was implied in an employment contract and hand out remedies when you can express the terms in a letter of offer? Letters of offer initiate and bind new hires to the employment contract. Here are a few guidelines to help you formulate your own. Confirm entry level, company benefits, and relevant company policies. Do not promise future promotional opportunities in the letter. You will be bound by it. Simply state what the position will be on Monday morning when the new employee starts. By stating that there are rules and regulations in the offer, it binds all new hires to those policies without having to list each one individually. Require that there be the successful completion of studies if recruiting for graduates. It may appear obvious, but there are still quite a few cases where recruiters have been embarrassed when their offers are accepted immediately by final year students who have no intention of finishing the semester. Provide information on job location, all reporting relationships, and starting salary. Stating the boss's name, or at least the name of the department where they will be employed, sets up the legal mandate required by the boss to conduct performance appraisals. Confirm only the starting salary. Never promise or allude to future pay treatments to the employee. In addition, do not base the letter of offer on a yearly salary. Tie the offer to prorated pay periods. State the hourly, weekly, bi-monthly, or monthly amount only. State any conditions that will affect the employment, such as probation, proprietary information, and any restrictive covenants. An organization has the right to make any lawful condition of employment. If there is a probation period, mention it. If the employee will be restricted in the type of work he or she can carry out after termination, make sure to mention it in the letter of offer. If there is any confidential information that must not be used externally, let the candidate know. Require the candidate to respond to the offer by a specific date. Close the offer legally by stating an expiry date. Open-ended letters of offer can cause significant problems. As unlikely as it seems, applicants have suddenly decided to accept an offer several months after the recruiter has hired someone else for the position. In addition, it is generally not good business practice to allow an applicant time to use the offer to negotiate with another company. A letter of offer should never come as a surprise to the applicant. Everything should have been agreed to in the interview, and the letter is merely a confirmation of the agreement. Please read the sample letter of offer handout for this module. We'll now look at legal constraints. Hiring an employee who is bound by an existing contract with his or her current or previous employer. In other words, beware of prospective employees with legal constraints. When hiring employees of a competitor, care should be taken to minimize the chance of legal action taken by the competitor against both you and its former employee. A little foresight can do much to avoid the worry and expense of a long and expensive lawsuit. When you hire one of your competitor's former employees, there are no fewer than 3 grounds upon which your competitor can base a potential lawsuit. First, breach of written covenant. If your competitor has a written covenant with its former employee prohibiting that employee from 1. Working for you or another competitor, 2. Soliciting its own former clients, or 3. Disclosing any allegedly confidential information to you, both you and your new employee may be held liable for any resulting damages suffered by your competitor. In these circumstances, your competitor could also be successful in obtaining an interim injunction preventing you from using its former employee in a way that is useful to your company. As a result, you could find yourself not only having to pay a large sum of money in damages and legal fees, but also saddled with a new, highly paid employee who is effectively unable to be of any real service to your firm. Not all restrictive covenants exacted by your competitor from its former employees are legally binding. If a court can be persuaded that the restrictive covenant is unreasonable in that it goes further than what is strictly necessary to protect your competitor's legitimate proprietary rights, the covenant will be struck down. The question of whether a particular restrictive covenant is so unreasonable as to be legally invalid is not easily answered. A court will look to all the circumstances of your competitor's business and to the nature of the proprietary interest which it seeks to protect through the covenant. Accordingly, a lot of study should be given to the wording of the covenant and the nature of your competitor's proprietary interest before jumping to the conclusion that the covenant is invalid and that your company's defiance of the covenant will be excused by a court. A common and serious error made by companies is to assume that because a competitor's restrictive covenant prohibits a former employee from competing in a large geographic area for several years, the restrictive covenant depends less on its geographic scope or its duration than on the nature of your competitor's business itself. In one famous case, a court upheld as reasonable, and hence legally binding, a restrictive covenant which prohibited the employee from working for any competitor for many years anywhere in the world. The basis for this decision was that the nature of the company's business, munitions, was worldwide. Next, breach of fiduciary duty. If the former employee had a fiduciary relationship with his former employer, he is prohibited from unfairly competing against his former employer after he leaves his employment, even in the absence of a valid restrictive covenant. This ongoing fiduciary duty also precludes him from taking advantage of any ripening business opportunity which might present itself after he leaves, which he may have learned about while working with his former employer. Accordingly, a fiduciary employee who resigns for the purpose of joining a competitor and competing against his former employer may be found to be in breach of a fiduciary duty to that employer. If so, both the employee and the new employer may be liable to the former employer for damages. For an employer to be a fiduciary, he must have exercised a certain degree of independent discretion or power. In addition, the former employer must have been vulnerable in a business sense to the actions of the former employee while on the job. In attempting to ascertain whether a prospective employee is a fiduciary of a competitor whose hiring makes your company a party to a breach of fiduciary duty, courts will look not so much at the official description or title of his former position as at his routine responsibilities. All too often, companies and their legal counsel fall into the trap of assuming that simply because a prospective employee is in a junior position with a competitor, it naturally follows that he cannot be fiduciary. On the contrary, courts have held that even salespeople and messengers can be fiduciaries and have severely penalized their new employers for hiring them anyway. Courts throughout Canada's 9 common law provinces have held that very low-ranking employees who exercise a certain degree of independent discretion and autonomy in their day-to-day dealings with their employer's customers and who develop a close relationship with those customers may in fact be bound by a fiduciary duty not to solicit customers. In addition, even where a junior employee is not himself a fiduciary, a court may nevertheless impose fiduciary duties on him either, 1. If it is discovered that he did something dishonest prior to leaving his former employee, like taking with him corporate documents or a client list, or lying to his former employer about his future job plans, or 2. If the court finds that he is competing against his former employer in concert with another former employee who is senior to him and who is fiduciary. Accordingly, when hiring an employee away from a competitor, it is essential that the following steps be observed. The employee must be told to return all documents and client lists in his possession to his former employer prior to leaving. In the weeks leading up to his departure, the employee must take care not to be seen nosing around his former employer's files, apparently trying to pick up or memorize valuable client information. The employee must not resign in concert with other more senior employees to join your firm. It must not look as though the former mere employee is resigning for the purpose of helping the more senior fiduciary employee compete unfairly against their former employer. It is always helpful if the employee has some objective problem that he can point to in his relations with his former employer to meet any later accusation that he resigned for the sole purpose of harming his former employer. Finally, breach of confidentiality. Even when the employee has signed no valid restrictive covenant and was not a fiduciary of his former employer, he may still be found guilty by leaving his former employer with confidential information and using this as part of his merits when joining your company. If this happens, your company will be jointly liable in damages to his former employer, even for sales of products that incorporate, even indirectly, such confidential information. As a general rule, an employee will be found guilty of breaching his duty of confidentiality if he divulges trade secrets or copies client lists, but not where he uses the skills, general knowledge, and personal goodwill which he acquired over the course of his former employment to compete. It is important to note that some courts have held that even where the employee does not take any written corporate document but deliberately memorizes it prior to leaving, he is in breach of his duty of confidentiality. Also, courts have held that an employee may be in breach of his duty of confidentiality simply where he gains knowledge about relatively straightforward technical production processes, which may have only taken a few hours to develop, prior to joining his new employer. If your company hires an employee who has technical knowledge about your competitor's production process, a court may assume that he is divulging this information to you, even though there may be no direct proof that he is, or even intends to do so. In this case, both your company and that employee may find themselves with an injunction preventing the employee from working for you at all. Some courts now distinguish between 1. Specific trade secrets, and 2. Information which, although originally confidential when it was imparted to the employee by his former employer, is not readily separable from the skills and knowledge acquired by him during the course of his employment. Courts will generally be reluctant to grant an injunction to prevent disclosure of this latter category unless the employee signed a restrictive covenant acknowledging that the information was confidential and promising not to divulge it to any future employer. Conclusion. The law of restrictive covenants, fiduciary duties, and confidentiality is complex and on some issues still obscure. It is never possible to entirely eliminate the risk of a successful lawsuit against your company by a competitor on any of these three grounds. However, if you happen to be the departing employee and are concerned about a potential lawsuit from your past employer, you should consider the following precautions. 1. If you have signed a restrictive covenant not to compete against your present employer, it would be wise before jumping ship to insist that your new employer give you some guarantee that it will help you with legal costs and continue to employ you in another capacity if a court orders you to refrain from competitive activities for a new employer in your chosen profession. 2. If you have been exposed to confidential information, make it clear to your employer that you will not be taking any of this information with you, and also that you will not be using your knowledge of this information when working for a new employer. Make it clear to a prospective employer before agreeing to join him that you cannot work in a capacity which will require disclosing or even using this information to compete on his behalf. Contract law, agency and company recruiters who hire from competitors. Third-party and company recruiters are becoming increasingly concerned about the legalities surrounding recruiting key human resources from other organizations. An interview conducted by the Association of Professional Recruiters of Canada, APRC, with William J. Manuel, a Toronto lawyer specializing in labor relations, revealed some interesting information. Please read the handout titled Professional Recruiters of Canada Interview with William J. Manuel. Now we'll look at employment standards legislation. Every province and territory is a legal entity and has complete jurisdiction within its borders. This means that there is not one approach to employment legislation, but 13 approaches. Such is the nature of confederation. Through a process of compromise and consensus reached in each jurisdiction by local employees or voters, employers and politicians, a series of minimum employment standards has been established. Here are some of the more obvious differences from province to province and province to federal. 1. The definitions of employer and employee differ from province to province. What this means is that who is excluded from the Act and who is covered by the Act differs between provinces. 2. Severance pay must only be paid to certain employees in Ontario and to certain employees who are federally regulated. Therefore, it is irrelevant to recruiters from other provinces unless they are federally regulated. And 3. All of the details of the Act are different from province to province and federally. For example, some jurisdictions have limits on the maximum number of hours employees can work, others do not. Some jurisdictions give many statutory holidays, others do not. All jurisdictions have overtime provisions, but the number of hours that an employee must work differs from province to province. Recruiters must understand that these minimum standards are, in reality, a collective labor agreement for employees who do not belong to a union. Unlike a negotiated collective agreement reached solely between an individual employer and its employees, grievances and violations are handled by an employment standards officer rather than the full adjudication process provided to unionized workers. A major advantage for employees covered by a provincial minimum standards is that they have access to the courts to redress dismissals. Unionized employees have only the provisions of their negotiated agreement and the arbitration system when being dismissed or when grievances arise. The adjudicators and arbitrators act as judge and jury, and their rulings are legally binding to all parties. What does all this have to do with recruiters? Everything. The hiring practices of their companies must comply, at least, to the province's minimum standards. This means that the terms and provisions of a recruiter's letter of offer must provide at least what the provincial standards provide to all non-union workers. Minimum wages, paid holidays, severance pay, notice periods, hours of work, and overtime are just some of the items covered. An office that provides anything less than the minimum is not a valid contract, even if the employee agrees and signs the offer of employment. No worker can waive his or her rights. Every recruiter must buy, read, and understand their province's employment standards to ensure their employer's hiring practices are not in violation of the current laws. These standards change frequently, and regulations under these acts exempt and add many occupational groups. A professional recruiter keeps abreast of these changes and informs management of the consequences. Okay, let's look at the various legal jurisdictions we know exist in Canada. The federal jurisdiction. Federal work, undertaking, or business. Navigation, shipping, transportation. Railway, canal, telegraph, banks. Ships, ferries, airports, aircraft. Radio and broadcasting stations. Any work that crosses or joins provincial boundaries. Provincial jurisdiction. Work performed within provincial boundaries. Work originating from the provincial base. Minimum employment standards. The idea for a series of employment standards across Canada was to give employers certainty in the labor market. Employers requested and were given a line which separated fair from unfair labor practices. This line lays out the minimum required by law. The courts encourage employers to provide employment conditions above the line, and that's why, if there's a claim, the courts will always award damages way above this line. But it is certain that any practices that fall below the line are violations of employment standards legislation. Labor or employment standards are enacted by both the Parliament of Canada and the provincial territorial legislatures. The jurisdictions of the provincial territorial legislature and federal government derive from the Constitution Act, sections 91 and 92. Jurisdiction interpretation of these sections gives provincial territorial legislatures major jurisdiction, with federal authority limited to a narrow field, as we discussed earlier. Provincial territorial authority is derived from the Property and Civil Rights subsection of the Constitution Act. The right to enter into contracts is a civil right, and since labor laws impose certain restrictions on contracts between employers and employees, they fall within provincial authority as property and civil rights legislation. The Yukon and Northwest Territories were, until recently, subject to the federal government's jurisdiction, but Parliament has enacted legislation to grant virtually the same powers to the territories as to the provinces. Employment standards cover such areas as statutory school leaving age, paid general holidays, minimum age for employment, annual vacations with pay, general hours of work and overtime, family-related leave, minimum wages including gratuities, call-in pay and deductions, recovery of unpaid wages, equal pay, termination of employment, equal payment, severance, etc., and weekly rest day and Sunday closing. Consider this. The following are some of the standards that vary from province to province and from province to federal. You should be aware of both the federal standards as well as those of your own province. Maximum hours per week. Overtime begins after X number of hours. The rate of overtime. Hours before eating break. Call-in pay, paid hours. Number of statutory holidays. Maternity or paternity leave. And minimum wages. Role of Federal Adjudicator, Provincial Employment Standards Officer. Search premises, books, and records. Collect monies due from employer. Pay the claimant compensation. Do any other thing that is equitable in order to remedy or counteract impact of the violation. Let's look at the Labor Relations Act. Recruiters will have to know about this act for several reasons. A labor relations board oversees collective bargaining in the provinces. It decides who can unionize and who is exempt from the Labor Relations Act. The reason for its existence is to actively encourage collective bargaining and to actively penalize any employer for interfering with the rights of the workers to belong to the union of their choice. The penalties can have a significant impact on an organization. Here are 4 reasons why recruiters must understand this act. The first reason is a recruiter who spends time in the interview assessing how applicants feel about unions, or who screens out resumes that contain any reference to the applicant's past union activities. This is a violation of the Act. The second reason is where the recruiter or other HR officer is asked by employees of the organization who are undergoing a certification drive if they should sign the union application card or not. In this case, the HR staffer may innocently and honestly provide his or her own opinion and respond with anti- or pro-union sentiments. In either case, it's not what you say that is legal or illegal, it's the effect your statement is having on the employee's decision to vote one way or the other. This is a violation of the Act. The third reason is contract related. Consider a situation where the recruiter is hiring into a unionized environment and does not inform the applicant of this in the interview process. Shortly after the applicant is hired, he or she finds out there is a collective agreement in place and union dues are being deducted from the salary. Aside from the applicant's unwillingness to belong to a union, he or she can claim the contract of employment offered more than the net salary received after union deductions and can sue for damages. The fourth reason is employment agency temps. Many companies are under the impression that they have found foolproof ways to lower payroll costs and limit their liability under current labor laws. Hire temps and contractors through a third-party agency. At first glance, trading permanent staff for temporary and contract workers through the use of employment agencies appeared to be the way to go. However, for the purpose of collective bargaining, the Ontario Labour Relations Board does not care whether the employees at the worksite belong to the employer or whether they are under contract to an employment agency. When employees want to join a union, the board is required to determine who is the actual employer of these employees by using 2 tests, the control test and the organizational test. The control test is simple. Here are the questions that will determine the outcome. 1. Who actually exercises direction and control over the employees performing the work? 2. Who really bears the burden of remuneration? 3. Who imposes the day-to-day job assessment and discipline? 4. Who has the authority to hire and fire staff at the workplace? And 5. Who do the employees perceive to be their employer? For the organizational test, the board will take a different approach. They will endeavor to make an objective assessment of the degree to which the employees in question are integrated into the employer's business. With these 2 tests, it is obvious that the board would grant virtually all agency temps the right to vote if there was a union drive at the workplace. The only way out for the agency is to separate their workers from the clients by giving the temps uniforms and sending supervisors from the agency to distribute and oversee the work. Even so, the board would consider the agency and the client as one employer. This would cause the agency to be a union as well. These are violations of the Labor Relations Act. This, in turn, triggers the Labor Relations Board intervention in the employer's affairs and allows them to apply a broad range of remedial measures up to and including automatic certification. Violation remedies. If the employer has contravened the Act so that the true wishes of the employees are not likely to be ascertained, the board may, on the application of the union, certify the union. If the employer fires or disciplines an employee for associating with or supporting a union, the employer is in contravention of the Act and will probably be ordered to reinstate the employee and pay all back wages. Threats, promises, coercion, and intimidation by the employer will cause automatic certification, even if the representation vote is less than 45%, or will result in certification with no vote at all. Powers of the Labor Board. Establish rules and procedures for its hearings. Determine the units for collective bargaining. Certify trade unions. Conduct representation votes. Hear and determine any disputes. Enforce attendance of witnesses. Examine employers and union books. Decide whether a person is a manager. Order representation votes. require an employer to post notices. Some exclusions to the Act: managers, confidential employees, HR staff, and senior administrative employees working with senior management and who have access to confidential and sensitive records. So who is a manager? What's to stop employers from calling all their employees managers and thereby excluding them from joining a union? The Labor Board decides who is a manager and who isn't, and here's how they decide. By the degree of influence the position has on hiring and firing, granting time off, granting or recommending promotions, granting or recommending wage increases. Certification. Certification is the official designation given by a labor relations board to a trade union and the exclusive bargaining representative for the employee in a particular bargaining unit. This allows the employees to deal with their employers collectively through a union rather than individually. The union represents the employees in negotiating and reaching agreements with employers on wages and working conditions for all persons covered by the certification, regardless of whether or not they are members of the union. Certification is granted after the Labor Board is satisfied that there is an appropriate group for collective bargaining. The union must represent more than 50% of the employees in that group. Where the board is not satisfied that the membership is a true reflection of that group, the board will conduct a representation vote. If the union feels that a vote will not disclose the true wishes of employees because of employer interference, it can apply to the board to be certified without a vote. Collective bargaining. Once the bargaining unit has been granted, the union begins. It can give the employer notice of its desire to start bargaining. Either side can give such notice. This is usually done within 60 days of the board being satisfied that there is an appropriate group for collective bargaining. Where there is a collective agreement already in place, notice to initiate bargaining for the renewal can be initiated by either party. If either party refuses to negotiate or appears to be bargaining in bad faith, then the other can apply to the board for an order requiring the offending party to bargain in good faith, or they can be prosecuted. If the board gives its consent to prosecute, criminal proceedings can be carried through the provincial courts. If during the negotiations both parties cannot come to an agreement, then either party can apply to the Minister of Labour for conciliation. The conciliation board usually consists of 3 people. Rarely, on the first collective agreement, does the minister grant a conciliation board or panel. The minister will normally issue a no-board report. 17 days after this report, the employees can be locked out or go on strike. Any other time is illegal. The parties then may apply to the minister for mediation. Any time after the commencement of a legal strike or lockout, the employer may request the Minister of Labour to direct a vote of the employees in the bargaining unit as to their acceptance or rejection of the employer's final offer of the matter still under dispute. Strikers cannot be fired for being on strike. Grievance and arbitration. If a member of a bargaining unit, the union itself, or the employer feels that the terms and/or conditions of the collective agreement have been violated, or if there is a dispute about the interpretation of a part of the agreement, a grievance can be filed. There are usually 3 or 4 steps set out in the collective agreement, and at each step, someone higher up in the organization gets involved. If the grievance cannot be settled by the steps set out in the agreement, then either party may arrange to begin the arbitration proceedings. An arbitrator or a board of arbitration performs functions similar to a judge. Their decisions are binding, and failure to abide by them is contempt of court. Please take some time to work through case study number 3, found in your handouts for this module. Why employees join unions? Size of employer. Mere bigness creates problems. Mass production industries learned long ago that the coldness and impersonality of the traditional large industrial plant may cause workers to feel alienated and adrift in their jobs. Labor unions are drawn to employees who are disinterested in their work and alienated from the company that employs them. This is, of course, a fundamental problem that affects not only attitudes towards unions, but also morale and productivity. Equally true is that unions view large bargaining units with greed. More members, more dues collected. Fragmentation. The larger the employer, the more likely it is that fragmentation will occur among the workforce. The result may be that various employee groups will disassociate themselves from the company that employs them and will instead develop into cliques, focused on themselves rather than the welfare of the company as a whole. When these groups feel that their interests are not receiving sufficient rewards and attention, they may turn to a union to champion their cause. Management and supervision. Employee dissatisfaction with management is a root cause of nearly every organizing drive. Often, the complaint is not over wages or benefits, but rather issues about their immediate supervisors. Common employee complaints to union organizers involve real or perceived favoritism by supervisors stemming from inconsistent application of company rules and policies. Unions strive to drive a wedge between supervision and employees by arguing that employees need an outside party to protect their interests and serve as their voice in the plant. In fairness to supervisors, most are well trained in the operations of their plant or facility, but rarely have received formal training in the human relations aspect of supervision. Often, this stems from the day-to-day pressures at companies to manufacture and ship quality products to their customers. Today's pressures, with just-in-time inventories and global competition, have impeded supervisory training. Non-monetary causes. Specialists in labor relations believe that union organizing activity seldom can be explained by a single identifiable cause of dissatisfaction. Instead, they believe employees gravitate towards a union when their overall feeling about their jobs and working environment is negative. Many elements may enter into an employee's attitude toward his or her job, and different employees, of course, may be motivated by different factors. Now, on to the Occupational Health and Safety Act. Recruiters will have to know about this act for a very important reason. This act oversees health and safety in the workplace at the provincial and federal level, and this means there are also 13 approaches to this legislation. They all lay out the minimum safety standards required and empower workers to deal with actual or perceived violations. The penalties can have a significant impact on an organization and on the recruiter as an individual, and here's why. Consider a situation where the recruiter is hiring into a workplace that requires special protective gear. The recruiter is under the impression that the union steward or the health and safety committee will do their customary new hire orientation on Monday morning, but for some reason they don't, and the employee dies or is severely injured on the job. In this case, not only will the organization as a whole pay heavy damages, but a criminal investigation will be conducted to find out who was individually responsible for the death or injury, and they will fine him or her and put him or her in prison for criminal negligence. This means that recruiters should protect themselves and their organization from any violations to this act by ensuring prospective employees are aware of the health and safety policies of the workplace and sign a copy of them, along with other pre-hire documentation, before the prospective employee sets a foot in the workplace. There are 3 overall objectives of this legislation, and it is directed towards workers. 1. The right to participate. This empowers workers to be directly involved in developing any of the organization's health and safety rules, policies, or procedures. It puts them on equal terms with management when it comes to initiating or implementing any health and safety programs, and when solving problems and resolving health and safety issues. 2. The right to know. This empowers workers to find out and know how safe or unsafe the tools and chemical agents that they use in the workplace may be, through easy-to-read instructions on their safe handling and storage, and what to do in case of accidents while using them. 3. The right to refuse. This empowers workers to refuse to carry out any work they believe to be dangerous without fear of retribution. The burden of proof always rests with the employer to prove that the work is safe. It also provides a step-by-step process to resolve refusal to work actions in the workplace. Look at how the Act implements these three objectives. 1. The right to participate. Health and safety committees are the employee's vehicle to participate in health and safety issues. Committees are required in workplaces where 8 or more workers, office included, are regularly employed or where a designated substance regulation or toxic substance order applies. Committees must consist of at least 50% workers and the rest management. There should also be a safety representative on construction sites of over 8, and at workplaces as requested by the Ministry of Labor. Powers of the Health and Safety Committees. They can conduct workplace inspections, investigate all accidents, attend refusal to work hearings, make recommendations and implement improvements, meet at least once per quarter, keep minutes of all meetings. The right to know. WHMIS, or Workplace Hazardous Materials Information System legislation, tries to reduce the incidence of illness and injuries resulting from the use or presence of hazardous materials in the workplace. The goals of WHMIS are training and education, to train and educate personnel about the use and handling of hazardous materials or chemicals, even toner. Labeling, to ensure that all hazardous materials are properly labeled to inform staff for use and handling, hot, cold pipes, etc. Data sheets, or MSDS, material safety data sheets to advise what chemicals exist, what they are, who to contact in case of emergency, and how to use and store it. 3. The right to refuse. If an employer disciplines an employee who refuses to work, the employee can complain that he or she is being penalized. The employer then must prove that the employee's refusal was of a frivolous nature. The employer can attempt to assign another employee to the work pending investigation, as long as he or she informs the second employee of the first employee's refusal and the reason. The second employee has the right to refuse also. The worker promptly reports the circumstances to the supervisor. The supervisor investigates accompanied by the worker, a health and safety committee representative, or union shop steward. The worker remains in a safe place unless assigned to an alternative until the investigation is complete. An inspector or specialist is notified by the supervisor. 5. The inspector investigates in the presence of the worker, employer, or union steward. The inspector provides a decision in writing to the worker, employer, and other representatives concerned. Laws for employers. All safety equipment is provided and maintained. Carry out all measures and procedures. Ensure all equipment is used as prescribed. Provide information, instruction, and supervision in the language of the majority of workers. Assist and cooperate with the safety committee. Post a copy of the Act in the workplace. Monitor levels and intervals of exposures. Provide all workers with written instructions. Keep and maintain accurate records of the handling, storage, use, and disposal of biological, chemical, or physical agents. Establish an occupational health service, a room with a stretcher and first aid kit. Make records available to affected workers. And notify director of the introduction of any chemical. Laws for supervisors. Ensure workers adhere to all safety regulations. Advise workers of all potential H&S dangers. Provide written instructions in the language of the majority of workers. Uses or wears equipment and protective devices required. Laws for workers. Work in compliance to the Act. Wear or use all equipment required. Report any defect or absence of protective devices. Report any contravention to the Act. Must not use or operate any equipment or work in a manner that may endanger him or herself or others. Workplace Safety and Insurance Workers' Compensation Act. Occupational health and safety legislation tries to prevent accidents from happening. Workers' compensation legislation deals with accidents that have already happened. Some employers are mandatorily included by regulation, and some are covered because they have sought coverage by application. A vast majority of employers are covered by workers' compensation, although not all are. Under the Act, for coverage to apply, it is necessary for an employer to be included. Examples of industries that would only be included by application are banks, insurance companies, trust companies, other financial institutions, recreational and social clubs, and associations, church, theaters with live performances, broadcasting stations, trade unions, motion picture productions, educational and recreational camps, and law offices. The reason we have to know about this act is because of contractors, consultants, or temporary agency workers on your company property who have injured themselves. If the employment agency or the employers of these workers do not have WCB or other insurance coverage, then your company will be treated as their employer, and you will have to pay their claims and bear their accident records, leading to significantly higher premiums. The two overall principles of workers' compensation legislation are collective liability and no-fault compensation. Collective liability. The legislation establishes collective liability as an insurance fund that pays for accidents, injuries, and illnesses. The employer pays into this fund. It is illegal for employers to deduct the premiums from employees for this fund. It is all employer-driven. Premiums for any given industry are established for all employers in the industry who are regulated to pay a percentage into the fund based on their past accident experience. No-fault compensation. The no-fault provision in the legislation allows that even if employees are negligent and are injured, they are still entitled to compensation. There is a cap on the money paid out. No-fault compensation means that in order to balance the right of no-fault payments, the employee has given up the right to sue the employer or anyone else in the organization. This is the reason that employers are willing to pay the WCB premiums and not be looking at costly suits for damages. The overall aims of the Act are 1. To provide payment for lost wages, 2. To provide medical aid, and 3. To help with rehabilitation of the injured. Law for employers under the Act. 1. Register with the WCB. 2. Provide accurate payroll data. 3. Make payments assessed by WCB. 4. Provide a safe workplace. 5. Ensure first aid is given immediately. 6. Record first aid treatment or advice given to the worker. 7. Provide immediate transportation to hospital, a doctor's office, or the worker's home. 8. Complete and give to the worker a treatment memorandum form. 9. Submit to the board within 3 days an employer's report of accident or injury. And 10. Pay full wages and benefits for the day or shift on which the injury occurs. Please take some time now to work through case study number 4, found in your handouts for this module. Let's tackle human rights legislation. The code is clear in its intent, and it's obvious how recruiters and hiring managers are impacted by this legislation. No person shall refuse to refer or to recruit any person for employment, dismiss or refuse to employ or to continue to employ any person, refuse to train, promote, or transfer an employee, subject an employee to probation or apprenticeship or enlarge a period of probation or apprenticeship, establish or maintain any employment classification or category that by its description or operation excludes any person from employment or continued employment, maintain separate lines of progression for advancement in employment or separate seniority lists where the maintenance will adversely affect any employee, discriminate against any employee with regard to any term or condition of employment because of any of the following: race, ethnic origin, ancestry, citizenship, place of origin, color, religion, creed, age, sex, pregnancy or childbirth, marital status, pardoned offense, record of criminal conviction, physical handicap, mental handicap, drug or alcohol dependence, place of residence, political belief, source of income, language, social origin, harassment, sexual orientation, family status, military service. This is a current, comprehensive list of all grounds of discrimination in all jurisdictions. Verify with the Human Rights Commission in your jurisdiction. Here are the various types of discrimination that are defined by the Human Rights Commission. Direct discrimination. This involves when an employer, normally motivated by malice against an individual's minority characteristic, deliberately and willfully intends to penalize him or her with respect to some other term or condition of employment. An example of direct discrimination: the provision in some human rights statutes that exempts from the definition of age the attainment of 65 years, thereby raising the question of the constitutionality of such a provision in the context of mandatory retirement at age 65. Indirect discrimination, sometimes called systemic, adverse effect, or disparate discrimination. This dictates that prescribed discrimination exists where the seemingly neutral, non-discriminatory policies and decisions of an employer result in members of a protected group sustaining disproportionately adverse effects. The remedy for such discrimination may include the imposition of an affirmative action hiring policy, such as a hiring quota in favor of members of a protected group in question, fashioned by a state agency such as a Human Rights Board of Inquiry or Commission. An example of indirect discrimination: the exclusion of domestic servants from some or all of the protections of the employment standards statutes in some provinces, which arguably constitutes indirect discrimination on the basis of sex, since the vast majority of domestics are female. Discrimination by association. A simple example of discrimination is a case where a person may not be hired because he or she is married to a person from a minority group, like Native peoples, African Canadians, etc. Constructive or systemic discrimination. A prime example of constructive or systemic discrimination is the way in which police hiring practices used to stipulate certain height and weight requirements, thereby excluding women and certain minorities who are generally shorter and lighter than white males. Another example is the setting of educational requirements that are unreasonable to create a barrier to those groups who have the least access to education. Here's the day-to-day impact on recruitment and selection practices. Recruitment advertising. No employer or person shall publish, display, circulate, or broadcast any words, symbols, or other representation in an advertisement for employment that indicates directly or indirectly that any prohibited ground is or may be a limitation, specification, or preference for a position of employment. Application forms and interviews. No person shall use or circulate any form of application for employment or make any written or oral inquiry that expresses either directly or indirectly any limitation, specification, or preference as to any prohibited grounds, or that requires an applicant for employment to furnish any such information. Employment agencies. No employment agency shall discriminate against any person on any prohibited ground in receiving, classifying, disposing of, or otherwise acting upon applications for its service, or in referring an applicant or applicants to an employer or anyone acting on his behalf. Although you can subcontract recruitment and selection to third parties, you, the employer, are totally responsible for the way third-party recruiters operate. If they are discriminating, even without your knowledge, the Human Rights Commission will still come after you. It is up to you to make sure that your agencies are complying. Trade unions. No trade union shall exclude from membership or expel or suspend any person or member or discriminate any person or member based on any of the prohibited grounds. Bona fide occupational requirements for refusal to hire. In the event that employment is refused or terminated based upon a bona fide occupational requirement of the position, there exists a complete defense to a human rights complaint under human rights legislation. This defense requires the employer to prove that the discrimination in issue arises from a specific and required aspect of the position in question that has been implemented in good faith and for good reason. In order to prove this, the employer must demonstrate that a failure to meet the requirements generally imposed standard would result in a real risk to the employee or to the public. Bona fide occupational requirements, therefore, are difficult to prove. Examples of valid bona fide occupational requirements: female security officers who must do personal searches of women. Liquor servers must be over 19 years old. Religious schools. Teaching and administration staff of religious schools are allowed to hire within their own religion only. Associations promoting the interests of a particular group. The Chinese Association or Women's Lobby Group do not have to hire outside of their groups. Defending bona fide occupational requirements. 1. That the qualification must be essential and directly related to the essential duties of the job. 2. The Commission will not find a bona fide occupational requirement reasonable unless it is satisfied that the circumstances of the individual cannot be accommodated without undue hardship on the employer, taking into consideration the 1. Cost of accommodation, 2. Health and safety requirements, and 3. Outside sources of funding. Cases of invalid bona fide occupational requirements. Driver's licenses. Recruiters should exercise caution before asking job applicants for valid driver's license or to successfully pass a color vision test, because in some cases these requirements may be discriminatory. Consider the human rights case where a driver's license requirement discriminated against a blind applicant. She was refused the job as an employment counselor because the employer claimed the job required traveling to various employers around the city. The employer claimed that a valid driver's license was a bona fide occupational requirement and that an accommodation based on her handicap could not be made because it was an essential duty of the job. The Human Rights Tribunal disagreed. The investigation showed that conversing with the employers was the essential duty and forced the employer to rearrange the geographical territory so that she could use public transportation to reach her clients. Another case involved an applicant who applied for a job as a police officer. She failed the pre-employment color vision test and was excluded from the candidate base. The applicant filed a human rights complaint because she claimed that it was not necessary to have perfect color vision to be a police officer. The Human Rights Tribunal found that the police used an initial color vision test that had been used for many years to test for 100% accuracy. The applicant claimed that 100% accuracy was not needed in the job as a police officer. She claimed that the duties of a police officer required only to correctly identify the color of cars, clothing, and objects for evidence purposes. She proved that she could do this even with her color disability. The Human Rights Tribunal agreed and forced the police department to use a less rigid and more realistic color vision test in its initial assessment of job applicants. It is vital that recruiters question the entry requirements of their organization and assess the impact these requirements are having on the 4 target groups. It is not up to the organization to decide whether or not a bona fide occupational requirement exists. When these employment barriers are challenged, it will be the courts that will make this decision based on the essential duties of the job. Employment medicals. There is still much confusion surrounding an employer's right to conduct a pre-employment medical exam in light of rigorous human rights legislation that protects the disabled. To eliminate the confusion, the recruiter should first know that current human rights legislation clearly prohibits the use of pre-employment medicals as part of the application process. This means no medical inquiries or exams during the attraction or interview phases of recruitment. On the other hand, medical exams will be considered as a bona fide occupational requirement if conducted under the following conditions. 1. Under a written offer of employment. This means that the successful applicant can be required to undergo an exam once the hiring process is made, and as long as it is common practice to have a medical exam for that position. Another acceptable approach would be to require all applicants to undergo a medical exam as long as the letter of offer is not conditional upon successfully passing the exam. 2. Where the specific physical abilities required to perform the essential duties of the job are defined. This means that a careful position analysis must be carried out in order to determine exactly why these physical requirements exist in the first place, to identify any needless employment barriers in the job. 3. Where the exam is limited to determining the person's ability to perform the essential functions. This simply means that if an applicant needs perfect vision to do the job, then rejecting him or her for poor hearing is discriminatory. 4. Where the essence of the business would be undermined. This means that the disability would severely affect the business as a whole, and where the safe performance of the job would be threatened by someone who lacked the specific physical abilities. 5. Where those failing to pass are reasonably accommodated as part of the process. This means that even if they fail the medical exam, the employer will take the time to assess whether or not reasonable changes in the job will enable the applicant to carry out the essential functions. The court may decide what is reasonable if a dispute arises. Accommodation. There are 9 rules of accommodation that employers should take the time to learn, and wherever possible, train managers to apply. 1. Employers shall accommodate the disabled with dignity unless undue hardship is created. 2. Dignity encompasses privacy, confidentiality, comfort, and self-esteem, and could be a primary consideration. 3. The costs of accommodation will be too great only if the essence of the business will be affected adversely in a substantial way. 4. If the risks involved in accommodating a disabled individual outweigh the benefits, then there is undue hardship for the employer. If the risk to the individual or other workers do not outweigh the benefits, then safety standards may be waived to provide accommodation. 5. Costs, which would be too great if introduced at once, may be phased in over time. As well, if accommodation is too risky in the short term, changes to allow accommodation can be phased in over time. 6. If the best accommodation is not possible, other areas which still respect the rules should be examined as possible methods of accommodation. 7. The onus of proving undue hardship is on the person responsible for accommodating. 8. The person seeking accommodation has to cooperate. And 9. Evidence of undue hardship must be objective. In applying these rules, remember that objective evidence will mean scientific proof, verified data, actual financial costs, or experts' opinions. Casually prepared documents or personal opinions will not be enough. With this in mind, costs that may prove undue hardship will include capital or operating or other quantifiable expenditures. Accommodation clarification. Consider this. A computer programmer was employed by an Ontario government department and put on a standard probation period for a year. He suffered from depression but did not report this to the employer until 8 months later. His work also suffered because he was absent for several weeks, but his doctor allowed him to go back to work. At the end of the year, the employer let him go for failure to meet the minimum standards of performance, and he filed a complaint with the Human Rights Commission claiming the employer did not accommodate his handicap as required under the code. The Commission initially wanted the employer to extend the probationary period for another year. The Board of Inquiry, however, dismissed the complaint because there was no evidence that an accommodation would have enabled the complainant to meet the required job performance. The Board also clarified the obligations of the employees and employers when accommodating the handicap. An employee must inform the employer about any hidden handicap and that special treatment is desired. The employer has no obligation to lower its standard to the actual performance of the handicap. Extending a probationary period to allow the handicapped employee to prove they can reach the standards is one example of lowering the standards. If the cause of poor performance is due to a medical condition, it is up to the employee to work with the employer to find a way to overcome the handicap, not the work. An employer can refuse work to a person whose handicap will prevent him or her from ever doing the work. A person who by reason of handicap cannot work competently on a regular basis is considered incapable of satisfying the essential requirements of the position and, regardless of how he or she might perform when affected by the handicap, is not entitled to a job. It is the employee who has to be accommodated, not the work. There is no obligation for the employer to hire or to retrain a person with a handicap who cannot perform the job, simply because the employer has the money to tolerate reduced standards. This decision and the subsequent clarification by the Human Rights Board of Inquiry on accommodations runs counter to the conventional interpretation of the code by the Commission. It is apparent that the pendulum is swinging in favor of employers during these tough economic times. Employment equity. Before discussing employment equity, we should briefly look at the Charter of Rights and Freedoms. The Charter applies to all governments in Canada and provides for the protection of certain basic rights and freedoms. These include freedom of religion, freedom of belief, the right to vote, fundamental legal rights, the right to use either official language, and the right to equality without discrimination based on race, national or ethnic origin, color, religion, sex, age, or disability. The Charter of Rights, like any other Bill of Rights, guarantees a set of civil liberties that are regarded as so important that they should receive immunity, or at least special protection from state action. If a law or a government act is challenged, and if it is found by a court to violate one of the civil liberties guaranteed by the Charter, the court will declare the law or act to be invalid. Before discussing what employers must do to promote employment equity, it is important to understand the rationale behind it. Each of the designated groups, women, Native Canadians, visible minorities, and handicapped, experiences disadvantages in employment differently. Generally, they experience higher rates of unemployment than other people, face more discrimination than other people in finding and retaining jobs and being promoted, are, despite being qualified, often overlooked or denied opportunities because of this discrimination, are underrepresented in most areas of employment, especially in senior and management positions, and are overrepresented in areas of employment that provide low pay and little chance for advancement. Equity plans. Employment equity simply sets out to eliminate the disadvantages of being a member of a target group. What must employers do to promote employment equity? Regardless of the vehement debate surrounding this issue, there appears to be a quota system. Collect data from your own company and compare them with the national demographics. Employers are expected to show the same representation in their organizations of the target groups as there is in the population at large, and fill position at all levels of the organization. If, for example, there are 20% visible minorities in the Canadian population, or at least from where you draw your labor pool, then 20% of your workforce should be made up of visible minorities and hold positions at all levels of your organization. What do you do if certain groups never apply for jobs in your organization? Can you be exempt from hiring them? Absolutely not. You must create an aggressive equity plan and do whatever it takes to attract these people to your organization. For example, find out what newspapers and journals this group reads and advertise job vacancies in them, or go to their community centers, their schools, wherever they congregate, and make your jobs well known to them. If these people are not qualified for the job, you are required to set up programs to train them in a manner that allows them to compete on a level playing field. Employers bear the cost of preparing target groups for vacant positions in their organization. Categories generating the most violations: age, birthplace or origin, sex, marital status, race, color, religion, creed, citizenship, education, records of offense, physically challenged, references, memberships, or non-business. We will review the questions on application forms and in the interview that seem to give job applicants the motivation to fill out a complaint at the Human Rights Commission, and that head to top of the list of violations to code. Age. On the application form, all you can ask is, are you between 18 and 65? And in some jurisdictions where mandatory requirement was abolished, then the upper limit of 65 is also a violation. Remember, these prospective employees can be asked for proof of age or any other proof required when they're filling out your organization's forms before they start work. Very few jobs require specific age. As we've seen, those who sell or serve liquor may be required to disclose this on the application or in the interview in some provinces. Birthplace, origin. Nothing on your forms or in the interview. Sex and marital status. Nothing on your forms or in the interview. Rarely will you ever win a case against a mother, regardless if she's currently pregnant or states she wants children soon. Full accommodation must be given. Mothers must never be penalized for having taken time off to have a child. This means seniority, commissions, bonuses, perks, and benefits accrue as if she had been at work. Mothers must not suffer financially in any way for having children. If there is a legitimate need for travel, simply state this as a requirement of the job and make sure male applicants are asked the same question. Race and color. Nothing on your forms or in your interview. Religion or creed. With regard to religion, in every single case the employee wins. There is a case about a Seventh-day Adventist versus Eaton's. The applicant misrepresented himself during the interview. The job he applied for was Thursday night, Friday night, and Saturday. Once he was hired, he said he couldn't work Saturday because of religious reasons. The store let him go because he was hired for weekend work. He complained to the Human Rights Commission and the store had to find him work on another day of the week. In the interview, you might say, you are given 8 statutory holidays a year. Will you be requiring any other days in addition to these? Don't ask them if they're willing to make up the time, take vacation days, etc. This is a violation. They get all the regular holidays plus theirs too. Citizenship. You cannot ask for their social insurance number until the person is hired. All you can ask is if they're legally entitled to work in Canada. Remember, you will get proof when they sign your documents before they start work. Education. You cannot ask for the name of the school they attended because it may lead to discriminatory grounds. For example, St. Pius School for Little Women, as it reveals their religion. Record of offense. You can only ask if it is relevant to the job. You can ask, are you bondable? Physically challenged. You must make reasonable accommodation. Parking, ramps, washrooms, etc. You don't decide what reasonable accommodation is. The Human Rights Commission does. Don't ask about previous back injuries or prior claims to WCB. The Human Rights Commission and the Workers' Compensation Board worked out a regulation whereby if an employee injures themselves at your workplace, you must take them back up to 2 years later and modify the work if needed to be accommodating to them. References. This refers to character references, not business references. It was used to find out which groups they were affiliated with, which led to discriminatory grounds.